Order.
So then, Mr. Havi.
My lords, before you is my motion dated 9th June 2025. I have filed submissions with respect to that motion. The submissions are dated 23rd of June 2025. There are 4 questions upon which we seek determination in this motion. On the first question, whether the petition filed by the first petitioner, Lady Justice Martha Koome, should be assigned to someone else. I mean, the bench to hear that petition should be a bench assigned by someone else other than the petitioner. It is not in dispute that the petitioner, Lady Justice Martha Koome, is the one who appointed this bench to hear this matter. The question arises whether a party to a petition, even if that party is the Chief Justice, can assign judges to hear a petition. The starting point is the case of Rigathi Gachagua versus the National Assembly. And in this decision, which we'll find at page 123 of the exhibits to the motion. This is what the Court of Appeal stated. So, what is to happen when the Chief Justice is, for whatever reason, absent physically or temporarily incapacitated, or when a matter certified as requiring empanelment relates to a matter where the Chief Justice is a party, or substantially relates to the office or person of the Chief Justice. Whereas the Court of Appeal did not give an answer to that question, the Court of Appeal affirmed that the decision in Leila Conchela, where Chief Justice David Maraga had delegated the duty of empaneling a bench of judges to hear, was the guiding factor. It is therefore our humble submission that, being the first petition in this matter, the prudent course for the Chief Justice was to delegate the function of appointing judges to hear a petition to the Deputy Chief Justice. That answers question number 1. Question number 2, whether the rest of the other 6 petitions should be heard by judges other than those assigned by the first petitioner, Honorable Lady Justice Martha Koome. It is not in dispute that my Lords Honorable Justice Lawrence Mugambi and Honorable Justice Bahati Mwamuye were both appointed to the office of judge in an interview presided over by the first petitioner, Lady Justice Martha Koome, as chair of the Judicial Service Commission. Of course, judges decide matters based upon facts and the law. There is no dispute about it. That's notwithstanding, there's also no dispute that perception of impropriety ought not to be entertained where there is legitimate fear for the same. And the guiding case on this principle is the Republic versus Sussex Justices. We have extracted it at paragraph 18 of our submissions. This is what the court said.
Where is it on the list number?
On the list of authorities, Sussex appears as authority number 9 on the list of bundle. In the submissions, we have extracted it at paragraph 18. This is what was said in Republic versus Sussex. But while that is so, a long line of cases shows that it is not merely for some importance, but it is for fundamental importance that justice should not only be done, but should manifestly and undoubtedly be seen to be done. It is therefore imperative to ask whether justice will be seen to have been done when two judges hearing the petition were judges appointed by the first petitioner. And this issue is not new. It has been the subject of litigation in other jurisdictions. In the case of the matter of the Chief Justice of Gibraltar, which we have extracted at paragraph 21 of our submissions.
And this number?
The case of, it appears as number 12 in our listed bundle of authorities. Intriguingly, the Chief Justice of Gibraltar in that matter was a judge of the High Court at one point in time here, Justice Schofield. Schofield faced a petition for his removal before the equivalent of the Judicial Service Commission in that country. What he did was to file a suit before the High Court, and in that country it's only High Court judges, and sought to stop the process for his removal. It was determined by the tribunal constituted to remove him with the affirmation of the Privy Council as follows. The tribunal was correct to hold that the action of the Chief Justice in bringing the judicial review proceedings constituted misbehavior. So it's our premise that it is misbehavior for the first petitioner, Honorable Lady Justice Martha Koome, to come before a court subordinate to her as the President of the Supreme Court and subordinate to her as the Chair of the Judicial Service Commission and seek relief before that court. It is even egregious for the first petitioner, Honorable Lady Justice Martha Koome, not to see the impropriety of empaneling a bench to hear the petition. Still on the Rigathi Gachagua case, which applies in that regard, the question is this: is the bench as constituted fit for purposes of the criteria set out in law for a paneling of a bench? This is what was stated in the Rigathi Gachagua case. But the following must be taken into consideration when empaneling a bench: the expertise and specialization in the relevant area of law of a judge, judicial seniority, and with tremendous respect, much as I'm mindful of BAT versus Rent Restriction Tribunal, that any judge, whatever the age of appointment is fit to hear the matter. These are the words of the Court of Appeal. Judicial seniority and experience. The need for balance and diversity of perspectives, often achieved by selecting judges in varied legal philosophies, regional representation, or professional backgrounds, any prior involvement in related matters, the sensitivity of the case, and the corresponding need to uphold public confidence in the judiciary, avoidance of conflict of interest to ensure impartiality. My lords, FIDA have just been here. This bench is fully made. It's fully made. There's a problem. There's a problem. Where is the female gender in this bench? It doesn't meet the test set out in the Constitution and the Court of Appeal. Where is the consideration of judicial seniority? I handled Philomena Mwilu versus DPP, and all the 5 judges of the High Court empaneled to hear that matter were peers of the Deputy Chief Justice. They were peers, both in actual age and date of appointment to the bench. I handled Conchella. Again, all the 5 judges that were empaneled to hear that matter were peers in actual age and date of appointment to the bench. But fundamentally, the benches were balanced. There were 3 male and 2 female. They were fairly senior judges and other judges of recent appointment. And the Rigathi Gachagua case, the Court of Appeal emphasizes that the paneling of a bench of judges is not a lottery. It's not a mechanical exercise. It needs to take into account fundamental considerations. My lords, as I conclude, an application of this kind is one that we advocates never want to make. But we must make, because it is a requirement of the law that we need to make this application. I therefore humbly request that you return this file to the Chief Justice so that the Chief Justice can do the correct thing. 1, delegate the petition filed by herself to the Deputy Chief Justice to empanel a bench. 2, to empanel a bench to hear the rest of the 6 petitions in accordance with the principles set out by the Court of Appeal in the Rigathi Gachagua matter and in the Conchella matter. That is my humble request.